Welcome to Securing Your Brand with SecureMark Legal. On this podcast, we break down the legal side of branding and protecting your business without the legalese. From trademark, copyright, and contracting tips to real-world case studies, we're here to help you safeguard your business, your brand, and reputation. We are here to help entrepreneurs, creatives, and business owners protect what they've built through smart, strategic IP solutions.
Hello, I am Holly McFall, a trademark attorney. Welcome back to Securing Your Brand with SecureMark Legal, where we make legal stuff, especially trademarks, way less scary and way more actionable.
And I'm Melissa Jeda, also a trademark attorney. And today we're going to talk about what actually changed in 2025 and how that affects small entrepreneur businesses.
The USPTO, the United States Patent and Trademark Office, has made a number of changes in 2025. Yes, some of these changes began in 24, but were effective in 25. This includes a new website, new rules, increased fees, new procedures, and surprise, some new scam risks. So if you filed a trademark, plan to file one, or just want to protect your brand, this episode is for you.
And I'm Kevin Rosenquist, here to ask the, what does that mean in English? Questions?
How are we going to translate that? So today's episode, we're going to talk about how the USPTO changes affect small businesses and how you can actually make that work for you.
All right, so let's get right into it. We can let's start with the fee changes for 2025, the fun money stuff. So this is the first major USPTO fee overhaul in years. Filing fees, of course, increased. Things never decrease, right? They just always go up. One of the fees that's actually new for us now in 2025 is a surcharge of $200 per class or category if you don't use the standard text in the ID manual. So the USPTO has this manual with hundreds of different descriptions for goods and services. And most of the time we can find one that fits within your business. Sometimes though, if it's something new or unique that just simply that maybe the USPTO hasn't thought of before, we may have to write in our own description for your unique business. So just something to keep in mind that $200 is charged if the USPTO has to, I guess, do that extra work of figuring out what it is that you're trying to say. Another one is a $200 surcharge again per class for going over 1,000 characters. Now, in the past, in these descriptions, we've been able to just kind of really unlimited. I mean, you'll see some that are crazy that go on for paragraphs and paragraphs unnecessarily. But in the past, there's been no penalty or charge for that. Now the USPTO is charging, again, for their extra time and having to review all of those extra characters. So $200 for anything that goes over 1,000 characters. And then for each block of 1,000 characters after that, there's another $200 per class fee.
Wow.
Yeah, that can add up depending on how many different categories your business is filed in.
Absolutely.
Yep. And then maintenance fees. So for basically renewals down the line every 5-10 years, those fees have increased. So just something to keep in mind and look at. The strategy for this matters, picking correct classes, making sure that you're filed in the correct classes from the get-go so you're not double paying fees. Things like that.
So do we know why these fees are going up? Maybe a gold-plated filing cabinet in the office or something like that?
That would be cute, but I don't think so. Actually, it's quite the opposite. The USPTO is going more technical. They're hiring more staff and they're digitalizing their system completely. The increased fees are stopping some of the shortages that we have right now. Prior to 2025, the USPTO timeline to get assigned to an examiner was up to a year, sometimes over a year in some cases. Now the timeline to get to an examiner is a lot shorter. It's about 7 to 8 months, which means that you get your registration faster. It also is reducing some of the inaccuracies. Like Holly said, they're now charging you if you charge more than, have more than 1,000 characters. That's a significant change in the, laundry list of things that were listed for every class. You're no longer throwing the kitchen sink at it. You're really being specific about what you're listing, why you're listing it, following it within the USPTO ID manual. So you have to strategize. You have to think about what is it that I'm doing? What are my goods and services? How do I describe those to the public so they know what I'm providing, but at the same time, I'm not being so overly broad or so completely inclusive, that you're costing you more money in the long run. Not only time, but also, your filing fees and your maintenance fees as you go through it. Maybe you can fit into one class instead of 7.
So yeah, avoiding the file in every class syndrome that we used to be able to get away with if we needed to sometimes. Now there's a different analysis that'll go into it money wise. And again, budgeting for those higher costs. It can become a budgeting issue when we're talking about hundreds of dollars, sometimes per class multiplied, sometimes by 3 or 4 or 5 in some businesses. That can really add up.
I'm curious, you said that they're digitizing, they're going to a digital world, so they're adding some fees because of that. But is it also possibly because they are trying to take down some of the work because people are just, putting a million classes in there and they're trying to kind of reel that in a bit?
It, prevents a lot of litigation too. So, if people are specific about what they're doing, they've increased the number of examiners. They've now increased, what they're able to do online, how you can locate information online. That decreases a lot of the work that needs to be done in the future. And It also gets rid of some of the scammers. So one of the scams that was going on is they would file for everything and then send cease and desist letters when they're not really selling everything. So it decreases some of that risk also.
Yeah, that makes sense.
One of the other big things we've changed and we've seen a change in is how you have the replacement. So if you're thinking internationally and you're either filed internationally and you're going to file in the US, you don't have to go ahead and file for every class and every goods or service that you filed internationally. If you're going to be starting in the US and you're kind of phasing in, you're going to start your process in the US, you can do what they call a partial filing here in the US. You can file under the goods or services, the classes that you're actually selling here in the US. It doesn't have to be the laundry list that you're selling internationally. Also, the descriptions internationally don't always match the US descriptions. So you have to make sure that you do have the proper class description goods listed here that you're going to be filing in the US. So you can file only what is being filed in the United States or being sold in the United States. You don't have to file for the entire laundry list that was filed internationally. Internationally, it costs more expensive to file under the Madrid Protocol here in the US. It is more expensive than your standard US PTO trademark filing fee to bring that application here, that product here.
So if I only want to sell physical products to overseas, but keep online courses US only, I don't have to internationalize everything?
Exactly. You can treat it like an a la carte menu. Select only what you plan to commercialize internationally.
And how does this save money?
You're not filing in every class. You're not filing for all the goods, all the services. If you're only selling online opposed to selling physical goods, those are 2 different complete classes. So you're saving the filing fee now in just that. You're kind of testing the waters, seeing how it sells internationally. And then if you're going to be selling the product, the merchandise, or anything else here in the United States, you can add those classes with another application.
Okay.
It is $600 per class to file that international, to file that 66A Madrid Protocol filing here in the United States. So that gets expensive. If you're filing 4 classes internationally, but you're only selling 2 of those classes here in the United States, that can add up to a big savings now. And then in 5 years when we renew the application also. So your renewal fees will be less. Maybe during that 5 years, you do great and you go ahead and add more classes, more goods being sold here in the United States.
All right, so the third point we want to hit on is the Trademark Trial and Appeal Board, the TTAB. There's been some changes there. So the TTAB is where all the fighting happens, the litigation in trademark cases. So as of September of 2025, the initial time to answer in a proceeding increased from 40 days to 60 days. So more time to respond if you receive a challenge to your trademark, which is helpful. That can be helpful for small businesses without immediate legal support. If you don't have attorneys in your office on your team ready to jump right away, you have some time to look for an attorney, hire an attorney, get your legal plan in place, 60 days to respond. So that also gives you time to decide with your attorney if you want to defend the action, if you want to talk about settlement, or maybe going back and amending your filing to conform for whatever changes the opposing party is requesting.
So people can challenge your trademark after you file, immediately?
Once it's been approved, it's published for opposition. That trademark application can be opposed by a company that says, I think that you're infringing on my mark. You're too confusingly similar. You're using my brand or my name. I've been using it longer than you. There's all kinds of reasons that you can oppose a trademark. And now that you have 60 days instead of that 40 days, that gives you another 20 days worth to kind of step back and say, what do I want to do?
Mm-hmm. Okay, so that's basically just some extra breathing room.
Yes, exactly. More time, less panic. So the note that the opposition window stays the same. So the time period for that opposer to file their opposition hasn't changed. It's only the response time that has changed from 40 to 60 days. So it's important to monitor filings closely so that you know right away if an opposition is filed, so you can jump right on it, even though it has increased. You know, that time kind of flies by when you're talking about these complex trademark issues.
Absolutely.
And that's a good, point there, is to make sure you have your watch server set up and make sure that you are still watching the USPTO for other applications, other filings, and making sure that you track those filings if you think they're going to be confusingly similar. You can track filings by name, you can track filings by class or goods or services, depending upon the description. If you're looking for someone that is selling swimwear, and you don't want them to be confusingly similar, you also don't want them to be maybe using a slogan you're using that you're not trademarked yet. So you can track other filings or upcoming filings through the USPTO through a watch service. And that's a good point to remember at this point, that since there is only 30 days to oppose a mark before it gets registered during the opposition period, you want to make sure you're on top of it. It's not that long.
Mm-hmm.
We have a fourth kind of change, kind of something we saw in the works going on and kind of the trend in 2025. Genericness, descriptiveness. Does your mark describe or say exactly what you do? We know that you can't file a trademark for that. And the USPTO, the examiners, are kind of cracking down on that. And even the examiner's manual has now kind of strengthened that language of what is descriptive, what makes it likelihood to confuse with another mark, and how that mark is generic. You need to make sure that these are talked about with a trademark attorney, that you discuss your name, your idea, and from the very start, because the USPTO is cracking down, and we have seen it kind of as a trend. And now the manual even strengthens the language in 2025 as descriptiveness, genericness. If they're likely to confuse, all of that has been strengthened inside the manual to make sure that we are following, and all marks are unique and individual, describing the brands or goods or services that they do.
So what counts as descriptive? If my landscaping business is called something like Perfect Lawn, is that descriptive?
Yes, exactly. It describes exactly what you do. So if a competitor could really use that same term and naturally would in their business, like lawn service, then that would be considered descriptive. So if someone would search for that term in Google, for example, looking for a lawn service in Florida, that's a good clue that it's a descriptive name.
So I can't protect the name itself?
That depends. My favorite legal answer. It really is. So maybe you've been using it for a long time. Maybe your name is not Perfect Lawn, but maybe it's Kevin's Perfect Lawn, and you are Kevin. So it is your name. It belongs to you. And you've been in business for 15 years. You really have created and established a unique distinctiveness for your brand. You can have acquired distinctiveness by having used it for such a long period of time. For those companies that haven't yet registered for a trademark, maybe now it's time to start considering it before they even crack down further. The other thing that also kind of changed in between is also what's in commerce. What is use in commerce? What is your first day of use? Making sure those are the two required dates. So your first date of first use, that's the date you've made your first sale, no matter where, and the date of first use in commerce, the date that you put that product or service in commerce outside of your state. Think of it as I made a sale to someone that doesn't live in my state. I shipped a product outline. I provided a service to someone. If you live in a transient area, someone that's maybe a snowbird, if you live in Florida. If you're in a metropolitan area, maybe someone that lives across the city lines, across the state lines, sorry. That would be in commerce, so across state lines. Those two dates are becoming more and more important, and they're making sure that those are your actual dates. That's going to be a trend I think we're going to see in 26 too.
Okay, so shall we move on to scams and impersonations?
Eek.
My favorite.
So there have been a surge in USPTO impersonations in 2025. Scam tactics like lookalike emails, fake deadlines and fees, text messages, and physical mail. So just know that the USPTO will never demand payment by phone or text or email, never. It'll always come from the USPTO in official mail. And of course, if you have an attorney, the best rule to go by is check with your attorney first before you do anything. If it doesn't come from your attorney, likely a scam.
But if I don't have an attorney, how do I know it's real?
So if you're filing by yourself, you should check the TSDR. You filed your application, you're going through the USPTO's website. The TSDR is where the recordings are occurring. If an examiner or someone within the U.S. Trademark Office does something, they're going to post it into that. That's like your docket report for trademarks, just like a court docket report. And it will say there, what is the fee? What is the change? All of those things are going to be reported through your TSDR. Examiners are not calling you. They're not sending you a text message or sending you an email with an invoice attached to it for you to pay link here now. We have seen some that are pretty good. They're like USPTO1.gov. So they're like getting close enough, and they're mimicking the language that was in your application, and they've got your class and services. We've actually had a few clients that we've said repeatedly, anytime you get something that doesn't come from us, call us before you do anything associated with it. And they'll be like, I'm about to pay this invoice. I just want to make sure that I'm supposed to. No, you're not supposed to. No. They're quite sophisticated out there right now. They really are getting there. And obviously it's working because they're getting better and better at it. And there's more and more of it that we've seen. So
the rule to go by is don't pay an invoice someone texts me or that isn't in the USPTO system.
Correct. The USPTO will never text you anything.
I'm going to write that down.
I kind of feel that's a good thing around because scammers are all over, not just through the USPTO. You get a random bill that's for collection that you're like, I never saw that, doctor. I never did that. Or you should call and make sure. And don't just call the number that's on the invoice or that's in the text message or in the email. Actually call the number associated with the USPTO. Absolutely. Call the USPTO Trademark Assistance Center if you don't have an attorney and say, hey, I got this letter. Do I owe the USPTO money? They'll look it up. They'll let you know. And your attorney, you can just call Holly and I. We'll let you know too. All right. I guess that's a wrap for what has changed most importantly in 2025 that we need to look out for so that we can plan. We've got a budget. We've got to make sure we're listing in the proper classes and we have the goods and services described, that we're staying within that USPTO trademark manual for our goods or services. And if we're not, we want to make sure that we've budgeted for that additional cost and make sure that it is something that we can't find within that descriptive goods. If you're going to globalize, we can do a partial replacement. We don't have to do all of the classes that you filed internationally in another class of goods. So that way you can, what we're selling here, we can get our foot in the door. We can start within the United States without having to file for everything. We want to make sure we're choosing distinctive names. We're wanting to run our comprehensive search. And we want to make sure we set up that watch service because we have a short period of time in which to oppose someone else's mark.
Yep. So trademarks should be treated as an asset, not an afterthought, especially in 2025.
Or 26.
So that's our breakdown of the biggest trademark changes shaping 2025.
If you're an entrepreneur, small business owner, remember protecting your brand early gives you the best strength for your business and continues to protect your brand going forward.
And no one wants to fight a scammer or lose their name mid-growth. That stuff really matters.
Thank you for listening to Securing Your Brand with Secure Mark Legal.
You can find us at securemarklegal.com. We love to hear from you. We love to answer your questions and help you protect your brand.
See you next time.
See you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.